didn't mean to do that. A lot of the examples that I've run through aren't NEC related. They're kind of war stories about things that people do that, for me, as a lawyer with tries to take a commercial approach, yes, seriously, you could really learn better from. There are about a number of adjudications over the year where there's a plethora of routes to get paid. Interim application, delay costs, etc., etc. Final account, something that shouldn't be in the NEC, but in my experience, to take up John's point about wrapping things up at the end, occurs all too often. One of the things that clients, contractors or subcontractors down the chain have been apt to do over the last year, partly because of the confusion that's caused in the Construction Act on pay less notices, is to try and go for a quick win adjudication because a client or the project manager hasn't properly served a pay less notice or to setting out what the exact sum is due. And one case that was reported in the last year is the Matthew Harding case, where a contractor terminated a contract and then sought payment against the interim application because there wasn't a valid pay less notice. And the adjudicator found for the contractor. Happy days. Only the client thought, well, actually, that's actually a windfall. So the client started an adjudication to try and determine what the underlying amount was, which anybody would think was a pretty sensible approach. My take out from that, though, is that is there actually enough objectivity in the tactics that contractors and subcontractors pursue in quick win adjudications on attacking a pay less notice when it knows that around the corner you might get a second adjudication? And from my perspective, that comes out actually in terms of contract administration, project management, from overconfidence from a contractor as to its true level of entitlement and a lack of objectivity. I've had 3 adjudications or series of adjudications on this point this year, and in each case I've said to the contractor, actually, in my view, what you might only be doing is storing up further adjudications. Why don't you pick the phone up to the client and say, actually, we think you've made a bit of a mess of the pay less notice. We think we're entitled to X. Why don't we sit down and discuss the final account properly and come to a commercial settlement? A similar situation arises, similar observation take out from the St Austell printing case, which involved a situation where a contractor had 115 claims and cherry-picked the claims that it wanted to refer to adjudication, because these were he cherry-picked for obvious reasons, the adjudications, the particular disputes that it thought were strongest and had a better chance of success. And Justice Colson in the St Austell case said that, enforcing the decision, said that cherry-picking is permissible and is to be encouraged. The party trying to resist enforcement said you couldn't pick and choose, and that crystallisation of the dispute hadn't occurred, etc. And Colson gave that short, sharp shrift. Now, that must be right in terms of enforcement of the adjudication decision. The issues have been referred correctly. The adjudicator had decided the right question that had been set and came up with an answer. I take issue, though, slightly with the, and I did check that he wasn't here, with Mr. Justice Colson's observation that cherry picking is to be encouraged. Now, I take a sort of slightly simple view that when contractors and subcontractors come to me and they've got 10 claims that they say are worth £200,000, and they think that they've got 5 that are good claims that are only worth £100,000, wouldn't it be more sensible, rather than to go down the adjudication route, risk counter adjudications, to actually just advance the cases, the claims, the compensation events that have merit? It's quite a difficult bit of advice to get over to clients, in my experience, but it does provoke the obvious response from project managers, which is to adopt a wait-and-see approach to undervalue individual claims, and all of a sudden, before you know it, the distance between the project manager and the contractor is growing, unnecessarily. Did you really win? This is a case that involved 8 adjudications, 6 of which were challenged successfully in jurisdiction, 3 of which in respect of the appointment process of an adjudicator. In respect of 1, a claim for £187,000 was reduced to £17,000, and the claimant won 1 of 8. So happy days. If, as a construction lawyer, you'd think that that was great stuff. I have to say that serial adjudications are the worst of all worlds. I get the impression sometimes in NEC contracts, but in other contracts, that adjudication is a first thing that people think of. It's almost like a part of contract administration. And in my experience, multiple adjudications, there are a lot of the times no winners, because the cost of the adjudications, running several adjudications, means that the net recovery of adjudication is a lot lower. The chances of mutual trust and cooperation go out the window. The potential for arbitration at the end in order to try and rebalance, in this case the 7 defeats, increases, and the cost of doing so increases. And there are alternatives, and I'll come on to look at those very briefly in a moment. Quality of adjudicators. It started off when I looked at this as a bit of a dig at adjudicators, light-hearted obviously, but on reflection, actually some of these submissions, only one of which is mine, actually indicate a level of ignorance about the NEC that has, for me, a much wider, more fundamental question, which is, do you really want to contract under the NEC? I think in this room there's a lot of advocates, so the answer to that by and large is going to be yes. But then the next question is, does the person you're going to contract with really want to contract under the NEC? Do they understand the way that the NEC works, the resource issues, and do they want to contract under the NEC and then actually know how to do it? Because in my experience, the disputes that were referred in these adjudications, and these are real submissions, actually, for me, show a lack of understanding. A risk register was actually a list of notified events. This is a submission in an adjudication. Communications don't need to be made separately. I'll skip the next one, that was mine. An early warning notice was really a CEN. Emails attached with big lists of risks were actually compensation event notices. And site information was actually works information. I mean, it's cracking stuff. When you read it for the first time, you think, how am I going to respond to this in adjudication? Because it's daft. And then you realise the adjudicator thinks, actually, I need to consider that point, and I'm going to consider it seriously. You think, oh my goodness. Prospective and retrospective analysis. Ewan and I were here last year being deliberately provocative about whether there was a room for retrospective analysis in assessment of compensation events. Strictly under the NEC, obviously, they're anticipating prospective analysis. I've had another instance this year where compensation event after compensation event weren't being analysed, so we were able to convince an adjudicator that in looking at the prospective analysis, he ought to have a look at what actually happened at the end, so that the contractor in that instance wasn't overcompensated. Strictly speaking, not by the book, but quite a cunning argument. Rough justice. A lot of people think that adjudication is rough justice. You get a couple of weeks as a responding party to respond to the referral notice. And in the Broughton brickwork case, this is again about pay less notices and whether a pay less notice had been served on time. There was an email that showed that particular pay less notice had been served on time. The adjudicator missed it. And the adjudicator missed it because the defending party, who was advocating that the pay less notice had been served on time, had buried it in the documents. So the adjudicator missed it. Quite a fundamental issue, because it actually completely changed the answer. he decided that the pay less notice hadn't been served on time, when in actual fact it probably had. The courts enforced the decision because the adjudicator had answered the right question, albeit probably wrongly, and one suspects that this is an adjudication A that shouldn't have occurred. B has been the resisting enforcement in the courts has probably more to do with the consultants who've missed the drafting point in the adjudication, defending their position. Taking a step back though, is it rough justice? In my view, all of those types of issues should be sorted out in advance. If you're not ready to adjudicate, don't adjudicate. If you're not ready to defend an adjudication, there's a good likelihood that you've not thought about the issues sufficiently in advance when you're project managing the contract. Very, very briefly, adjudication is an option, it's not the only option. Objectively assess your entitlement. In my experience, people routinely are over-optimistic and unrealistic about their actual likelihood of recovery. I was always told as a youngster that in respect of delay and disruption, a well thought out, put together claim might get in the region of 30%. So if you actually think you're going to get 100%, you're not looking at the issue objectively. If you start looking at the issue objectively, you're more likely to come to a sensible conclusion. Adjudication is not suitable for a number of scenarios like multi-party disputes, but the bottom two, just to look at quickly, in terms of alternatives, the pre-action protocol in the Technology and Construction Court requires the exchange of information. As part of that process, before you're allowed to litigate in the court, or before you should do, there is usually a without prejudice meeting between the parties. In my experience, by and large, that takes the form of a mediation. And in my experience, that's an excellent way of avoiding the more cantankerous things that you see in adjudication. It avoids multiple adjudications, serial adjudications, and there is sometimes a potential that the parties go away and maintain their relationship. I'm running out of time. Part 8 is a procedure in the courts which enables parties to take a distinct contractual point and get a final and binding decision of the court. It's not something that is appropriate all of the time, but it's a great way of lancing a particular boil on a project if there is a lot at stake. Rather than having a series of adjudications that hang off one or two big issues that nobody is going to resolve, you can go off to court 1 day, 2 days before a court, get a final and binding decision. Just to end up, a couple choosing an adjudicator. This is quite an interesting case, and actually Justice Ramsey had some very strong words in the decision. The lesson learned, really, the takeaway is that it's all good to have cunning tactics, clever tactics, but don't ever be deliberately misleading. In my experience in adjudication, people sometimes get over carried away with the process. It's 28 days, there's too much emotion and not enough objectivity. In this instance, this was a case about the appointment of an adjudicator on a second adjudication. The first adjudication was on an interim application with various claims that had been decided by the first adjudicator. Eurocom didn't want that adjudicator reappointed on an adjudication about the final account because most of the disputes had already been decided. So they deliberately manipulated the appointment process of the RICS by conflicting out the first adjudicator. I say that I've seen similar tactics used in adjudications. Mr. Justice Ramsey, in this instance, suggested there was a strong prima facie case of fraudulent misrepresentation in the way that that application form had been completed by Eurocom, because it was a deliberate attempt to get a new adjudicator, knowing that the first adjudicator was likely to find against Eurocom again. So there was a potential financial benefit that they were hoping to derive from completing the form in the way that they did. So be clever, but don't be fraudulent, obviously. Don't get carried away. Try and be objective, because in my experience, the more subjective you are and the more emotional you are, the less likely you are to have an adjudicator come with you. And if you're adopting the same tactics in your project management, then it is likely that you are going to more likely to go to some form of dispute at some point. Finally, this I suspect isn't going to occur very often in your experience, but this is something that happened to me this year on a JCT. The JCT, particular form of JCT that we were employing, incorporated the scheme, which has got a confidentiality clause in it. A lot of NEC clauses have got confidentiality clauses in them, particularly in Z clauses, term service contracts, when you're working with public authorities. In this particular instance, the other side's project director wrote a letter to a number of similar companies in a particular segment of the market, complaining about my client's company, the board of directors, and saying that they had undertaken multiple adjudications because they were effectively crap at what they did, and they were manipulative. They ignored the fact that they'd won all 5 adjudications because of serial under assessment. But we went to the TCC. We followed the TCC protocol in mediation, and in the mediation we got the other side to pay £50,000 in compensation for breach of confidence, breach of that confidentiality agreement, because in breaching that confidentiality agreement, they'd lowered the integrity, the perception of our client in the business sector that they were in. I'd say I probably wouldn't have given £50,000 over, but it was a great object lesson in adjudications that went on to the next stage to TCC protocol of how too much emotion and a lack of objectivity can A, lead to a poorly delivered project, then lead to multiple adjudications, and then lead to a £50,000 windfall for breach of confidence. That's me.